Thank you very much, Tony, and thank you to everyone for attending. On 23rd of October 1909, the 13-year-old Elias Godfrey Coppel celebrated his bar mitzvah by reading his Pasha, or portion of the law in Hebrew, at the Burke Street Synagogue in Melbourne. The Rabbi, Dr. Abrahams, forecast a successful legal career for him, including promotion to the bench. More than 60 years later, he recalled this, saying, "I remember thinking that this was rather overdoing it." He was being self-deprecating. As a Queen's Counsel, he was for many years a leader of the Victorian Bar, appearing frequently in the High Court of Australia and the Judicial Committee of the Privy Council. His book on bills of sale earned him the rare distinction of a doctorate in laws, and he was for some years an independent lecturer in procedure and evidence at the University of Melbourne. He had articles published in legal journals and the Proceedings of the Medico-Legal Society of Victoria. He was a captain in the Australian Legal Corps in the Second World War, and he was created a Companion of the Order of St. Michael and St. George for his services to the law. But the rabbi's prediction of his promotion to the bench fell short of the mark. His judicial appointments were only temporary. He was appointed as an acting justice of the Supreme Court of Victoria for 3 successive years. Promises that his acting appointment would be made permanent were not kept. So he refused a further acting appointment and in 1953 returned to practice at the bar. He only acted as a judge. On 2 separate occasions, he later served as an acting justice of the Supreme Court of Tasmania. For reasons of time, I shall only speak today of the Victorian appointment. Some of this remains provisional and subject to research in the Public Records Office, which because of COVID restrictions I've not been able to conduct hitherto. He was given the name Elias after his grandfather, Elias Coppel, in accordance with Jewish custom. He didn't like it and wrote that the only advantage it ever had for me was that he left me a gold watch, which was presented to him on his bar mitzvah. For most of his life, he was known to close friends and family as Bill. Colleagues at the bar would call him Dr. Coppel or just Coppel. Use of the simple surname as a form of address is an old tradition at the bar. For convenience, I shall call him EGC. For a boy apparently destined for success in the legal profession, EGC's progress to the top of the ladder was slow, interrupted as it was by war and ill health. He enlisted in the AIF in June 1915 in the middle of his second year of university. He served in Egypt, where he was seriously ill with typhoid, and on the Western Front in the 5th Field Ambulance, and 4 years would pass before he was discharged and could resume study. Abandoning his incomplete arts degree, he concentrated on law and was admitted to practice as a barrister and solicitor in May 1922, and soon signed the bar roll, beginning his career as a barrister at the age of 25. By the end of 1923, he was feeling quite unwell. A sea voyage to Ceylon failed to improve his health, and specialists diagnosed tuberculosis. In those days, before antibiotics, that required a long period of rest and convalescence. He was only able to resume work at the bar after Easter 1925. By then, he was aged 28. He moved to the Equity Chambers building after its completion in 1931 on the site of the old synagogue where he celebrated his bar mitzvah. At the outbreak of the Second World War, he was recruited with the rank of captain to the Army Legal Corps. He had quite a lot of work at courts martial, in trials for desertion or absence without leave, attending as prosecutor, defending officer, member of the court, or as judge advocate. Apart from Army Legal Corps matters, he was also appointed by the Commonwealth Government to chair several boards of inquiry into malfeasance during the war. On 9th of January 1945, at the age of 48, he was appointed King's Counsel, or took silk, as lawyers say. It was almost 20 years after he'd returned to practice following his illness. Another war had delayed this step. It was not done to apply for silk during the war and thus gain seniority over other barristers who were absent serving in the armed forces. When he resumed his practice in peacetime, it was as a new silk, an appointment made for life which precluded doing work nominally done by juniors, for example, drawing pleadings. Moreover, at that time, whenever a silk was briefed to appear in court, a junior barrister had to be briefed to appear with him and be paid a fee equivalent to 2/3 of the silks. These requirements entailed risk for the silk. Older members of the bar were familiar with stories of colleagues whose practice had collapsed after taking silk. And there was a warning given in the accompanying letter from the Attorney General at that time that this was a consequence of taking silk, and it was a lifetime appointment. Fortunately, EGC was not to join the ranks of those whose practice collapsed. His practice thrived in the post-war environment. He was one of a dazzling array of leading barristers briefed by the private banks to challenge the Chifley government's bank nationalisation legislation, which posed an existential threat to them. The length of the original hearing probably set a record for the High Court, and similarly, the report in the Commonwealth Law Reports. You can see him there with Gar Barwick at the time of the High Court hearing in Melbourne in February 1948. The case fostered close and long-lasting friendships among the teams of lawyers gathered in Melbourne for the case. I'm not suggesting Barwick was one of those, including those coming from interstate. This growing collegiality was reinforced among those who appeared in the later appeal in London and with their illustrious senior colleagues from the English bar. 2 weeks after the High Court handed down its judgment in favour of the banks in August 1948, EGC and Frank Kitto with their wives were headed for London on board the Orion as an advance party to oppose the appeal by the Commonwealth in the Judicial Committee of the Privy Council. The month-long voyage established a lifelong friendship between the two couples. The Judicial Committee granted special leave to appeal in November 1948, but the barristers stayed on in London for the appeal itself, which came on for hearing in the Privy Council in March of 1949. It was an all-star cast, most destined for high judicial office. You can see, I'm not sure I can show this, no. You can't actually, I don't know quite how to move this. Well, I get.
I think that screen is probably just
it's covered.
What you get.
Or maybe I can move this. That's right. There we go. That's what I wanted to do. You can see there Sir Walter Monckton, Sir Cyril Radcliffe, Valentine Holmes, and Kenneth Diplock. Older generation lawyers at least will recognize these as stellar members of the English bar at the time, a number of whom went on to become law lords. Okay. Counting the return sea voyages, EGC was away from his practice in Melbourne for a period of 9 months, but his prominent role in this high-profile case did not harm his prospects of further work at the bar. But remarkably, within 20 months, he was to leave practice at the bar for what would prove to be a period of 3 years as an acting justice of the Supreme Court of Victoria, before returning to the bar in February of 1953 at the age of 56. This was not what he'd expected to happen. I have no doubt that he wanted a permanent appointment. For 3 successive years, he accepted an acting appointment on being promised that the establishment of judges would be enlarged and thereby make it possible for him to be given full tenure. Why did he want this appointment as a judge? Well, first of all, there was the general expectation that senior counsel would go on to judicial office. Many of his colleagues and friends from the bank nationalisation case did so. Perhaps there was also an element of fulfilling the rabbi's prophecy from 4 decades earlier, but I suspect that in his case there may have been an extra need for financial security. I've mentioned that war and illness had led to him having a slow start at the bar. At that time, however, his father was a wealthy man and EGC had expectations of a considerable inheritance. His father's bankruptcy in the 1930s depression meant that he no longer had any prospect of independent means. As a barrister, he had no superannuation. He was aged in his 50s before it became possible for him to purchase the house in which he'd lived as a tenant for 20 years. At the time of his first acting appointment, his youngest son was attending an expensive boarding school and had a further 5 years of secondary education to go. On the other hand, at that time, Supreme Court judges were appointed for life, with no mandatory retirement age. When they did retire, they received a pension and a gold pass for free travel on public transport. This financial security would have been important despite judicial salaries being low compared to the fees that leading silks could command. The fee for his appearance before the Privy Council in 1949 as one of 7 silks with a junior, admittedly an extreme case, as you can see from this, was 5,000 guineas sterling, which must have been close to 2 years' salary for a Supreme Court judge in Australian currency at that time. Why was he made an acting judge? The short answer is that the existing Supreme Court judges were few in number, and several of them were entitled to a year's absence on long service leave. Although Chief Justice Herring had managed to get the court's establishment increased from 6 to 8 judges, state governments were not in a hurry to make further increases. Making an additional permanent appointment required legislative change, an amendment to the Supreme Court Act. An acting appointment could supposedly meet the immediate need to cover the absence of a judge on long service leave. It was in this context that EGC was commissioned on 10th of February 1950 as an acting judge during the absence on leave of Justice Martin. This one-year appointment was followed by 2 more during the absences on leave of Justice Gavin Duffy and Justice O'Brien. Nonetheless, as we shall see later, undertakings were given that the Supreme Court Act would be amended and an extra permanent appointment made. As far as I know, EGC was the first Jew to be appointed to the Supreme Court of Victoria's bench. Some have suggested to me that anti-Semitism may have played a part in his not being offered tenure, but I've seen no evidence of this. As an adult, he was not religiously observant and he married out. My mother was a Gentile, but there were some vestiges of Judaism. He didn't work on Yom Kippur, the Day of Atonement, and he, as it were, showed the flag for his Jewishness by processing as a judge to the synagogue at the beginning of the legal year, when his Anglican and Catholic brother judges processed to St. Paul's and St. Patrick's, respectively. At the Jubilee Law Convention in Sydney in August 1951, he processed with Justice Sugarman of the New South Wales Supreme Court into the Great Synagogue, both wearing scarlet and ermine robes and wearing full-bottomed wigs, preceded by Justice Sugarman's tipstaff carrying the judge's mace. In Zalman Khan's biography for the Australian Dictionary of Biography, he wrote, "A leading member of the Victorian bar, Coppel proved an able and learned lawyer. In style and character, he was a man of contrasts. At times courteous, gracious and urbane, at others sharp, relentless, wounding and abrasive. Particularly on the bench, he seemed on occasions to show antagonism and hostility to counsel and to others who appeared before him." In this assessment, Cowan closely followed Kevin Anderson's 1986 memoir, Fossils in the Sandstone, who went on to say, he had the misfortune while on the bench of being antagonistic to counsel and also of having adjudicated in at least 2 cases in which members of Parliament were litigants. And comments which he made in those cases were, to say the least, not favourably received. I was in one such case, and his hostility to the parliamentarian, who was not my client, was ill-concealed. That's Kevin Anderson. I shall return to the question of these parliamentarians later. Anderson also cited a later example in 1959 when EGC's treatment of a witness when he was Royal Commissioner to inquire into third-party insurance. Anderson wrote, They were the opening lines of a 2-month inquiry. They set the tempo, and feathers flew in much the same way as they did when Coppel had been on the bench. I think he was unaware of the impression he created when in a position of authority. In May 2007, Juliet Brodsky conducted an oral history interview for the Victorian Bar with 4 judges and a silk. One of the judges, Bill Ormiston, said that he, Coppel, had been made acting judge on at least 2, if not 3 occasions in, I think, the early 50s. And it was thought that he would get the next permanent appointment because there was a numerical limit, as I recall, at the time, and he was only an acting judge. But he was never appointed because he made a sufficient number of enemies from the way that he conducted his cases, so it's said. Personally, I don't question the contention, which seems to have become a received wisdom, that EGC was a man of contrasts in style and character, and he did not suffer fools gladly. If, as Ormiston recounts, he was never appointed because he had made enemies from the way that he conducted his cases, this did not prevent his being offered a 4th acting appointment. And, as I will show, it was his own decision to decline the offer and return to the bar at that time because the new Labor government did not propose to increase the number of Supreme Court judges. There remains the question why he wasn't offered an appointment when a vacancy did become available. Why did he only act as a judge? I believe he was a victim of the instability and turbulence of Victorian state politics in the early 1950s. At that time, the parliamentary system had long been dysfunctional, with coalition or minority governments the norm. Political parties splintered and governments changed with shifting alliances and horse trading. The system favoured property and rural interests, giving the Country Party disproportionate power. The upper house, the Legislative Council, was elected on a restricted property-based franchise and had always had a Conservative majority. After the May 1950 elections, the Country Party formed a minority government with Labor support in return, among other things, for replacing the property-based franchise with adult suffrage. The lower house, the Legislative Assembly, was gerrymandered in favour of country electorates. The Liberal Party was divided and split on electoral reform, which was championed by Liberal leader Tom Holway. This led, after the December 1952 Legislative Assembly elections, to the formation of the first majority Labor government. In this 3-year period, in which EGC served as an acting justice of the Supreme Court, there were no less than 5 ministries, by my count, each with a different political complexion or composition. When the Attorney General Mitchell wrote on the 12th of December 1951 to ask EGC if he would be available for a 3rd acting appointment, he said, "I regret to inform you that a bill to increase the number of Supreme Court judges was not introduced into Parliament in the session that recently closed. Consequently, it becomes necessary to appoint an acting judge to relieve Mr. Justice O'Brien for a period of 12 months commencing on the 1st of February next during his absence on furlough." I have a handwritten note of EGC's reply, dated 19th of December, in which he said, "I refer also to our subsequent conversation in which you assured me that it was the expressed intention of the Honourable the Premier that I should be appointed permanently during next year as a judge of the Supreme Court. I'm now able to inform you that I shall be happy to act as a judge of the Supreme Court for a further period of 12 months, commencing on 1st of February 1952. 12 months later, the same Attorney General, Mitchell, wrote on 8th of December 1952 to ask EGC if he'd be available for a 4th 12-month acting appointment to replace the Chief Justice Herring while he was on furlough. He opened by saying, "I wish to inform you that, unfortunately, the Supreme Court Judges Bill, although passed in the Legislative Assembly, was not reached in the Legislative Council before Parliament adjourned." He went on to say, "Having regard to the fact that a new government will shortly be in control of the state, I'm unable, of course, to offer you any assurance as to the introduction of the said bill to Parliament at an early date." This last was a reference to the outcome of the Legislative Assembly election held just 2 days earlier, when the Labor Party under John Cain Sr. was able to form a majority government. Mitchell was now only a caretaker Attorney General. The handwritten note of EGC's reply, dated 11th of December 1952, reads, "Your letter of 8th of December reached me this afternoon," that's 3 days later. "You will recall that on 2 previous occasions when I was asked to act as a judge of the Supreme Court for the ensuing 12 months, the request was accompanied by your personal assurance that during the forthcoming year, my appointment would be made permanent. And in December of last year, this assurance was reinforced by your statement that I could also rely on the Premier's assurance to the same effect. The request contained in your letter under reply is of such a different nature that I should be glad if you would afford me a little time in which to consider my position before replying. I have no knowledge of when he refused the offer of a 4th acting appointment. The news became public in the media after the term of his last acting appointment had expired. According to the Herald of 3rd of February 1953, the Attorney General, Mr. Slater, said today that the government didn't propose to increase the number of Supreme Court judges. Dr. E.G. Coppel, who had been an acting judge for 3 years, found himself unable to continue in that capacity. He therefore proposed to resume his practice at the bar. He wished to express gratitude to Dr. Coppel for the service he had given to the state and the bench. It was a similar report in the Age on 4th of February, which added that Mr. Slater said Dr. Coppel had found himself unable to continue as an acting judge because the government did not propose to increase the number of judges on the Supreme Court bench. The proposed appointment of another acting judge would allay fears in legal circles that congestion in the law courts would become even more acute than it is at the present. On the same day, Sir Charles Lowe wrote on behalf of the Supreme Court judges to EGC saying, "At the meeting of judges this morning, I was asked to write you to express our unanimous appreciation of the services rendered by you to the bench during your period as an acting judge, and our regret that you find it no longer possible to continue in the capacity of acting judge." In the following week, he received personal letters from individual judges of the High Court as well as the Supreme Court. I'll return to these shortly. Before he left the bench, there had been one piece of business to conclude. It related to the most newsworthy case over which he presided. This was the 1952 trial of William John O'Meally for the murder of Police Constable George Howell. According to a report in the Argus, 24th of May 1952, the public gallery was packed for 2 weeks, filled to capacity with spectators who had waited in queues for long hours. On 23rd of May, the jury returned a guilty verdict after 4 hours of deliberation. EGC, in his full bottom wig and scarlet and ermine robes, in front of more than 200 spectators, then pronounced the mandatory death sentence that O'Meally should be hanged. This must have been an extremely stressful experience, not only for the accused, but also for the judge. EGC had not had a criminal law practice as a barrister, and this was a high-profile case. He had both to ensure that O'Meally received a fair trial and to avoid making any procedural errors that might lead to the verdict being set aside. Once the jury delivered their verdict, he had no discretion to pronounce anything but the death sentence. I can only speculate on what this might have felt like to a man who had spent years in a non-combatant role in the First World War. Possibly EGC drew to the attention of the new government the desirability of the cabinet addressing the issue of the execution of, in a rather literal sense, of O'Mealy's death sentence before he returned to the bar. At all events, he received a letter from the Crown Law Office on 20th of January 1953, asking him to be in attendance on the 27th of January. 28th of January, he was sent another letter informing him that the Executive Council had commuted the sentence to life imprisonment without any possibility of remission. Curiously, this letter mistakenly says that the death sentence was pronounced on 12th of May 1952, which was 11 days before the jury delivered its verdict. Among the personal letters sent by judges to EGC after the public announcement on 3rd of February 1953 is one from his friend and High Court Judge Frank Kitto. I have just learned that the situation you expected has arisen. and you've gone back to the bar. I really couldn't bring myself to believe that so wrong a thing could occur. I'm sure I needn't tell you how sorry, disappointed, and disgusted I am. To you, it's a flagrant injustice, and to the people of Victoria, it's an iniquity. But there is nothing to be gained by fulminating about it, and I'm not writing for the sake of giving vent to my feelings of bitterness that such a thing could be. I only want to say what a friend can say without being suspected of flattery, that if ever a man was able to leave the bench with his head high, you can. And all whose opinions need matter to you are sorry for the sake of Victoria to see you go. I still don't believe that the last word has been said. When you resume your rightful place, it will indeed be a great day. We in this place, that is the High Court, are selfish enough to be found congratulating ourselves that the number of arguments that really help will now receive an enormous increase. Another letter is from the Chief Justice of the High Court, Sir Owen Dixon. Quote, because I believe that you would prefer judicial life, I was sorry on your account to learn from the news that you'd return to the bar in view of the government's decision not to increase the number of judges. I'm also sorry that the bench has sustained such a loss, for your services to the bench were of the highest value. But it will be a very great advantage to the High Court to have you appearing before it again, and I can't believe that you will not find that both your true interests and your real happiness are best served by your return to the bar. You have a freedom of action and an independence at the bar for the loss of which the bench can offer no compensatory advantages that are adequate. No judge can ever experience the same influence or authority as an eminent counsel, and he is never held in the same respect as such a counsel commands. And as for obtaining satisfaction from judicial work, well, I can only say that mine yields none, nor is the load really any lighter. At the moment, you will probably disagree with all this, but the time will come when perhaps you will feel its truth. At all events, you have my best wishes for your happiness.
If we make just another 5 minutes, please, Charles.
I think I'll manage. And here is the letter he received from his Supreme Court colleague and friend Arthur Dean, also later Chancellor of Melbourne University. Note the second paragraph. I entirely agree with your decision in the circumstances, but I don't see how further appointments can be long delayed. Jack Kane won't always be short of money, and the true facts must emerge despite the Crown Law Department. When that day comes, your useful service must dispose the government to give you what is now withheld. Meanwhile, I hope you secure adequate pecuniary compensation. I believe that EGC shared the expectation expressed by Kitto and Dean that he would be appointed to fill the vacancy when the court was eventually enlarged. During the course of '53, the Law Institute of Victoria and the Victorian Bar made representations to the Kane Labor government for the number of judges to be increased and for an increase to the judges' salaries. There was a change to the Act, and on the 22nd of December 1953, Edward Hudson, acting Justice of the Supreme Court, who took on the position that EGC had been offered, was appointed to the new position. EGC wasn't offered the permanent position, despite the promises that had been made by previous governments. He was disappointed and upset that he had been passed over. Although less senior at the bar than Hudson, who'd taken silk in 1939, he'd been appointed as an acting judge earlier than Hudson and had served about twice as long on the bench. I've been told that members of the bar believed the position should have been offered to him, and that Morris Ashkenazi QC, then the bar chairman, was criticised for not pressing his case to the government. This takes me back to the remarks made by Anderson about members of Parliament EGC had offended, and by Ormiston about enemies he'd made when a judge. Ormiston went on to say, and it's one of the reasons why I think a number of us are very dubious about proposals for acting judges, because of the way in which people can, as it were, lobby against a permanent appointment of an acting judge just for personal reasons arising out of being dealt with rather hardly in court. I believe I've identified one of the two cases referred to by Anderson. This had to do with John James Dedman, who'd been a minister in the Chifley government. I won't, because of time, I won't read all that I had to do. He was the member for Corio, and he was defeated narrowly at that election by Hubert Opperman, former Olympian cyclist, who went on to become a minister in the Menzies government. A report in The Age contains this paragraph of the report of the case. At one stage when Mr. Deadman was being, he'd brought a claim for £10,000 damages against the Geelong Advertiser, and which he claimed was two political advertisements which he claimed had libelled him. At one stage when Mr. Deadman was being examined by his junior counsel, Mr. Justice Coppel said with a smile, "I must make it clear to you that your function is to answer questions. You may reserve speech making for elsewhere. I know it's hard to break the habit of a lifetime." On 16th of February 51, his case failed after EGC directed the jury to fine for the defendants. Although, and I am now winding up, Tony, I can only agree that his reported remarks were ill-advised. I think it was unfair and unwise of the then Chief Justice Herring to ask an acting judge to preside over such a political case for precisely the reasons given by Bill Ormiston. And the senior counsel for Deadman was Maurice Ashkenazi. His remarks in the Deadman case, I don't know about the other one Anderson referred to, may have been enough to spoil his chances of being offered a permanent appointment by the Labor government. The Premier, John Cain, and the Attorney General, Bill Slater, had both been elected to the Victorian Legislative Assembly as early as November 1917, and would surely have closely followed the Deadman libel case closely. And if, as bar chairman, Ashkenazi didn't press the government on EGC's behalf in December 1953, perhaps he may have been influenced by his experience as Deadman's counsel in 51. Speaking for myself, I'm glad that EGC returned to the bar and wasn't appointed to a permanent position on the court. Not only did it give me the opportunity to appear as his junior in court on several occasions, but I would not have had the experience of travelling with my parents in Europe in 1955. I'd like to thank help from this paper from Peter Ewell, Stephen Charles, and my wife, Susie Nixon. Thank you very much.
Good. Thank you very much, Charles. If you could turn off the screen sharing, please.
Yes, if I can find that somewhere, I'll get that down. I'll get that off. Whoops, oh, no, really.
Should be just that button at the bottom of the screen that you clicked to turn on screen sharing.
Yeah, no. Yeah, I can't see it. You are screen sharing, stop share, okay.
Yeah, that's great, thank you.
Sorry about that, okay.
Okay, well, thank you, Charles. Can I ask for any questions of Charles? Perhaps if I could start, Charles, you mentioned the possible antagonism over particular cases that may have affected the appointment. Was there any sort of residual annoyance or anger from the incoming Labor government over the bank nationalisation issue?
Well, the bank nationalisation was, of course, federal rather than state, and this was a state Supreme Court. So in that sense, the federal government was defeated along with Deadman in December 1949, and
yes,
came into power for a long time. I have no inside knowledge of the Labor Party at that time. What I do suggest is that with an Attorney General in Slater and a Premier in Cain, long-serving members of the Labor Party who would be fully knowledgeable of a federal cabinet minister in the seat of Corio, they would be surely on top of what had been said in that, and it was reported in the daily press. I mean, it wasn't, it was clearly he just couldn't resist making a crack in that thing. And as I say, I think that was ill-advised. But I should, I actually hand in the paper, which I didn't read, but I just mentioned that it was very shortly after that trial, 3 days after the end of the trial, his eldest son, my oldest brother, Hugh, died of osteomyelitis. And he was probably under a great deal of personal stress because of the illness of my brother at that time, is my hunch. But on the other hand, I mean, Anderson gives some very clear quotations of what was said in the later Royal Commission on Third-Party Insurance. It sounds very, the anecdote that he gives there of the first rather prominent witness who was called, who said that he was expecting to be in the witness box for a long time and he was not going to be standing all that time. And apparently my father, the thing that made the feathers fly was that my father said to him that he was the one who would decide whether somebody stood or sat, and that if at an appropriate time an application was made, he would consider it. But it was not for him to, and so on. So it was that set the tempo for the Royal Commission that lasted to 2 months, apparently. So he was not, the idea of him being, the courteous and urbane side of him is very true, and the sharpness and so forth is also true. I try to be as objective as I can, but it's not easy for the son of a man to speak.
Record that. Yeah, certainly. Okay, there are other questions, please.
Charles, June here.
June.
I was reminded, I can't remember the detail now, but I think I contacted you a while ago about your father when he was fairly young in the law, and he was giving advice to the military. And there was some issue about whether aliens who had come, this is in the Second World War, beginning off, aliens who had come from enemy countries, from Germany or Austria or Hungary, whether they could join the Australian Army. Do you recall that?
Yes, indeed. I have a copy of the advice that he gave, I think.
Yes,
and I think I shared that with you, if I'm not mistaken.
You did. But I think it's an interesting, you couldn't pick up every part of his life, but I think that was an interesting role that he played during the Second World War.
Yeah. Well, it links in with another thing, that my mother's activities in the civil liberties sphere, where she was secretary of a Victorian Immigration Appeals Committee, I think it was called, something like that. This was working to get the release of those who were in the Dunera boys, who were in the internment camps at that time. And so I think, it was, and she also gave a talk just just before the outbreak of war, in which she was describing, she'd given as a public speech. I think it was in the cathedral, the church, the Anglican church at Eastern Hill, is it?
Yes.
Which had apparently regularly had people speaking on public issues of social concern at that time, and she gave a rundown of what had happened in Germany under Hitler, with progressive restrictions on freedom of Jews and so on. So they were certainly, they were united in this kind of concern. What they didn't know was that one of the Dunera boys was a distant cousin, a second cousin, I think it was, of my father's. Mm-hmm. And it's one of the great regrets of my life that I've never been in a position to tell them that, because I only discovered this after they were both gone.
Thank you. Other questions, please?
Charles, Rosemary here?
Yes.
No, I'm interested, Charles, did your father ever have discussions with you about this incident? Were you ever able to talk to him about this?
look, I have no memory of it, Rosemary. You see, at that stage, I was, it was at the end of my, was it 53? I was still at school. It must have been a leaving certificate year, year 11 in today's terms. So I was not around. I mean, I was around in school holidays. No, he didn't actually.
No, I was just wondering whether later in life, you know, as you joined the law too, so whether you would have had general discussions. I don't know.
Well, what he did do was well, one thing he did was to write a memoir for his grandchildren, but he didn't go into that issue. He also left, he was fairly clear on what he wanted to remain and what he didn't want to remain. But among the things that he left were the correspondence that he received around all of this, and I read from some of those letters. So clearly it was a major issue for him, and he kept the copy of the letters he had received from Crown Law and from the Attorney General and so on, and his notes of his reply, his sort of shorthand type of, no, not literal shorthand, but his abbreviated handwritten notes of what he'd replied. Now, when I ultimately get, I hope, to the records, the archives, the Victorian archives, I'm hopeful that I can get the official, the actual letters that he wrote, and maybe can find other information there that can throw light on things. But yeah, there are some things that people don't reduce to writing, of course.
Yes, exactly. Oh, thanks very much, Charles.
Yeah.
Can I ask
Helen?
Yes, I just wanted to ask Charles, thank you very much for a terrific paper. I'm really, really very impressed. I wondered how he felt about you becoming an Indonesianist.
I think not so. My interest in Indonesia didn't worry him, but I did actually make the decision to leave the bar without discussing that with him. I informed him. And yeah, you get there into my own problems of, where I think the short thing is that I had gone into a law degree on his recommendation as a good preparation for someone who wanted to be a diplomat. And I went off the idea of being a diplomat fairly soon into the law degree, but by that point I didn't quite know what to do except go on to legal practice. I hadn't done a combined law arts degree, which probably would have been more sensible, because by the time that I started university, he was in his 60th year and he had no superannuation and so forth. And I just felt that this was, it was unfair to take on a double degree. And yeah, he'd enlisted the support of Sir Frederick Eggleston, who I went along and saw, to say what a good idea a law degree was for someone who wanted to be a diplomat. He'd had one himself. Anyway, so later on, I mean, I don't think that I was temperamentally suited to be a barrister or being a lawyer, but I hadn't found before I was engaged in practice as a barrister, I hadn't discovered what it was that I really wanted to do. And I had got interested in Indonesia. And, that goes into a whole personal story about
Yes, of course.
Meeting my first wife, who's the mother of Louisa, who's right next to you on my screen there, waving at you. And so she had been on a 3-month student trip, I think it was, to Indonesia, in a group of 5 or 6. And yeah, she then studied Indonesian. I studied with her. And well, my interest in Indonesia stayed longer than the marriage did, which lasted quite a long time, but not nearly as long as my second.
Thank you. Thank you very much.
So I think, Jean, did you have a question?
Oh, just a quick question. What I was hearing was that there was some kind of relationship between the appointment of judges and political parties. Could you comment on that?
Sorry, could you just repeat that, Jean?
I was hearing a subtext in the reasons you were giving for him not being made a permanent judge, being given a permanent appointment, the fact that the wrong party was in power.
Well, I think it's. I wouldn't say that that was the case in itself. I don't know that the person who was appointed, Hudson, was particularly favourable to the Labor Party.
Right.
I don't have any doubt that my father voted Liberal and that my mother voted Labor, but I think that I think it's more likely that it was his. I mean, as Anderson relates, his criticisms or his treatment of Labor parliamentarians would have spoiled his chances with a Labor government. I think it's also true that given the turmoil of those times, if it hadn't been the Labor government that had come into power at the end of 1952, I think that they would have come good. The Liberal Party would have come good with an enlargement of the court, which they had previously promised, and that he would have accepted if it was only for a short time, yet another acting appointment, and there would have been then an enlargement of the court and he would have been appointed. That's my belief. But you know, I don't know that I can push it further than that, Jane.
Okay. Volkard, I think you had a question?
Yes, I was wondering to what extent your mother played a role in your father's outlook on his work and on the law in general.
They had a very close intellectual relationship as well as a personal one. He certainly read drafts of papers that she wrote for the Catalysts and elsewhere. Also the book that she co-authored with Mary Lazarus, The Making of the Modern World, which was a set text for Year 11 Modern History in Victoria for years. Oh, excuse me. But I mean, she wouldn't have influenced his conduct of court cases in any way, Volkard. And they would have had numbers of disagreements on political matters.
How about his decision to not take the fourth temporary appointment?
Presumably they must have discussed it, but I think he would have thought, I mean, it's the lack of financial security. It's sort of a funny mix because the judges were paid so much less than barristers. And there was no doubt that but he had a considerable amount of ill health, and the chances were that something could happen, and then there was nothing else to fall on. And as I said, I was at that time, well, at the time when he refused the fourth one, I still had a couple of years to go of school, and Geelong Grammar is not a cheap school.
True. So one last question. We're coming towards the end of our time. Is any?
Yes. Is that
Can
Anne?
you see me? It's Anne, your cousin Anne. Hi, Charles. Very interesting. Thank you. I was just wondering, did we have a relative, Leo Lazarus, who was a QC, and did your father have any contact with him at all during the time he was in practice?
Sure. Well, I think he also became a judge, if I'm not mistaken.
He did, yes.
Yeah, yeah, certainly. I mean, I think, when I said that he was the first Jew to be appointed to the Supreme Court of Victoria, he was not the first Jew to get senior judicial office in Australia. And Sugarman in New South Wales was earlier. And of course, in the High Court of Australia, Sir Isaac Isaacs was Chief Justice and later became Governor General. So it's and yeah, at that level, there were other cases.
Thank you. Thanks, Charles.
Thanks, Anne.
Okay. Well, I think we've got to the end of our allotted time. So unless there is another very quick question anyone has, no, well, I think we'll just move on to thanking you very much, Charles. Ask everyone to join with me in thanking you.
Well, thank you all very much for coming.
Thank you very much, Charles.
And for your questions.
As a final piece, when Charles was first showing me some of these slides, he commented that the presentation was going to move from trial by jury through to the gondolas.
Gondoliers, yes.
So I'll ask everyone to leave the session with your favourite Gilbert and Sullivan's tune playing in your mind. So thank you again, Charles, and we'll look forward to seeing everybody next month for Faye Woodhouse's presentation.
Thank you very much.
Thank you.
Thank you.
Thank you.
Thanks, Charles.